Trump's trade war tariffs toppled, how U.S. courts pulled the plug on border taxes, and what happens next. The great ports of the United States awaken before dawn. Cranes, the height of skyscrapers, arc across gray skies, lifting containers that hold the daily necessities of a nation. Steel boxes from Shanghai, cotton shirts from Bangladesh, avocados from Michoacan. They arrive under a single financial rule. Imported goods pay a price at the border if Washington demands it. Recently that price has been set by one man, President Donald J. Trump, through a maze of executive proclamations. But on the morning of May 28, 2025, the architecture shattered. A three-judge panel of the U.S. Court of International Trade vacated the president's sweeping tariffs and permanently barred customs officials from collecting them. In the words of Chief Judge Diane Wood, the Constitution does not grant the executive a roaming commission to tax the nation. What follows is the story of how the ruling came to pass, why the judges deemed the tariff program unlawful, and what the battle means for factories, farms, and the global system of trade. This is Nexus Feed Breaking. Let's get started. The Constitution is explicit. Only Congress may lay and collect duties and regulate commerce with foreign nations. Over 2 centuries, however, lawmakers have delegated bits of that authority to presidents when emergencies beckon. Wars, embargoes, threats to national security. Donald Trump seized on one of those delegations, the International Emergency Economic Powers Act of 1977, a Cold War statute crafted to seize Iranian bank accounts and to punish rogue states. Trump declared successive economic emergencies that, he argued, justified tariffs on virtually everything America imported, 10% on all goods, double or triple that on nations posting persistent trade surpluses. His stated reasons ranged from opioid trafficking to illegal immigration to economic aggression. Critics, retailers, automakers, tech firms, governors of both parties, filed more than 30 lawsuits. They claimed the president had bulldozed 2 guardrails at once, the text of IEPA, which never mentions import duties, and the deeper constitutional divide between legislative and executive power. When Judge Wood and her 2 colleagues read their opinion from the bench, they embraced every major argument the challengers made. IEPA, they wrote, is about blocking money, not taxing socks or smartphones. Even if Congress had meant to hand over such a vast commercial weapon, it would have had to say so clearly, repeatedly, and unmistakably. That clarity was missing. 4 themes animate the 124-page decision. Separation of powers. The panel underscored that tariff authority is one of the sharpest blades in the congressional toolkit. Letting a president wield it without limit would erase a main pillar of the Republican design. The Major Questions Doctrine. Building on recent Supreme Court precedents, the judges warned that agencies cannot decide issues of vast economic and political significance unless Congress speaks plainly. Hundreds of billions in border taxes are, in the court's phrase, about as vast as it gets. Mismatch between ends and means. Trump's emergency declarations identified fentanyl, cartel violence, and labor trafficking. Yet the tariffs targeted countries only loosely linked to those harms, while exempting others intimately involved. That mismatch signaled an abuse of statutory purpose. Retroactivity and due process. Importers had already paid duties for years. The court held they were entitled to refunds, with interest, because the levies never had lawful footing. It ordered Customs and Border Protection to stop collections in 10 days, and to begin the long task of repaying companies that could document their claims. Law professors now speak of a Trump pattern whenever court orders collide with White House policy. From the early travel bans to the family separation injunctions, compliance often arrived late, partial, or not at all. In March, a district judge found the administration in contempt for deporting asylum seekers during a restraining order. The contempt fine, $95,000 per removed migrant, made headlines for a week, yet removals continued until the court hinted at jailing senior officials. That history colors every forecast of what happens next. Few observers believe the president will simply comply. He loses in round 1, appeals, and dares the judiciary to chase him, says Sarah Pierce, a Georgetown law lecturer who tracks executive branch pushback. That's been the blueprint. Appeal and emergency stay. Within hours of the ruling, the Justice Department filed notice at the U.S. Court of Appeals for the Federal Circuit. It will ask for a stay that would switch the tariff machinery back on while the appeal runs. Granting such a stay is discretionary. The judges must weigh harm to the government against harm to importers who have already paid billions. Statutory detours. If an immediate stay fails, the administration can activate other trade statutes. Section 232 of the 1962 Trade Expansion Act lets a president impose duties if the Commerce Secretary deems imports a national security threat. Section 301 of the 1974 Trade Act authorizes tariffs to counter unfair, discriminatory, or burdensome foreign practices. Both routes require investigations, hearings, and comment periods, a process that slows momentum and exposes new actions to fresh lawsuits. Legislative backfill. Allies on Capitol Hill talk of retroactive approval, though the path is steep. Many Republicans from farm states have grown weary of retaliatory tariffs that clobbered soybean and pork exports. Democrats, meanwhile, relish the optics of constitutional restraint. A quick statutory fix, therefore, may prove elusive. Administrative gray zones. In the recent contempt case, officials quietly revised deportation paperwork, but told field agents to keep flying migrants out until they received clarity. Trade lawyers anticipate something similar. Customs officers might be instructed to continue collecting border taxes out of an abundance of caution until higher courts speak. That sets the stage for contempt motions, penalties, and another courtroom drama. Corporate ledgers and consumer prices. Investment banks shaved 0.2 of a percentage point off their third-quarter U.S. inflation forecasts within hours of the decision. Apparel companies, bicycle importers, and electronics distributors say profit margins will open overnight if the stay request fails. Yet, the uncertainty of an appeal means few will rewrite long-term contracts until a higher court speaks. Exporters under the microscope. Foreign partners had retaliated against the Trump duties with levies of their own: whiskey, Harley-Davidsons, California almonds. Brussels and Beijing signaled they would suspend those counters so long as the United States refrains from reviving its measures. Should Washington reimpose tariffs under a different statute, the retaliation could snap back swiftly, landing on industries chosen for maximum electoral pain. Labor unions and swing politics. The United Steelworkers called the ruling a disaster for American industrial workers, adding that cheap foreign metal would flood the market. Retail groups cheered. The clash hints at 2026 campaign ads already drafted. One which says, "The court sided with China, we stand up for American jobs," versus another which points out that Congress, not kings, sets taxes. Watch out for their likely scenarios ahead. Scenario 1, the stay holds, appeal succeeds. Tariffs remain in force through late 2026 when the Supreme Court, perhaps with a reshaped bench, upholds broad emergency authority. Importers eat higher costs or pass them to consumers. Allies signal resignation and negotiate carve-outs on a case-by-case basis. Scenario 2, the stay fails, appeal fizzles, duties vanish for good. Congress may rewrite IEPA to clarify that only asset freezes, not taxes, fit inside the law. Trump pivots to Section 232 or Section 301, but must pick narrower battles: steel, chips, critical minerals, where national security arguments resonate. Scenario 3, legislative override. With midterm pressure mounting, Congress cobbles together a bill that retroactively blesses the tariffs, yet sunsets them in 2 years. The compromise shields swing district lawmakers, while giving the White House a victory lap. As of late May, bookmakers in London give a slight edge to Scenario 2, citing judicial skepticism toward executive economic emergencies and the tight timeline before companies begin claiming billions in refunds. All that said, there is a human face to all that is happening. At the port of Long Beach, customs broker Maria Rojas toggles between screens. One tracks Korean washing machines, another French wine. Each shipment carries a tariff code, a duty rate, and now a question mark. If they flip the switch off for even a week, importers will flood us with refund requests, she says. But if the appeals court reactivates tariffs, we have to claw the money back with interest. It's chaos. 2,000 miles east in Monessen, Pennsylvania, third-generation steelworker Mark DeMarco hears the news on a dusty shop radio. No tariffs, no mill, he mutters, recalling the layoffs of the 2000s. Tell the judges to clock in here for a week and feel what unfair trade looks like, he adds. Their voices illustrate the dilemma. The legal fight is constitutional, but the stakes are concrete. Paychecks, grocery prices, diplomatic alliances. There are reasons this moment matter beyond tariff. Scholars frame the decision as part of a larger reckoning. How much unilateral power should any president wield in the modern administrative state? The same courts that curtailed the Environmental Protection Agency's regulation of carbon dioxide, or the CDC's eviction moratorium, have now rebuked a trade war born of proclamation. Professor Neil Katyal calls it the year of the major question. Each branch rereads its script, and the unscripted spaces shrink. Trade policy, once a realm of bipartisan committees and 1,000-page bills, may return to that slower grind. Or Congress might prefer delegation but tighten the leash, demanding time limits, explicit objectives, periodic votes to renew. Whichever path emerges, the tariff ruling forces lawmakers to choose rather than drift. A court opinion, typed in black ink on white paper, altered the color of global commerce overnight. The cranes at the harbor still swing their cargo, but the cost of each container is suspended, literally, in midair. Some celebrate a vindication of constitutional design. Others mourn a tool they believe protected American labor. All recognize that the question is bigger than duties. It is about how a republic balances urgency against restraint. As the appeals advance, as Congress debates, as allies gauge their next moves, every invoice and every payslip becomes a ledger of civic philosophy. The tariff may yet return, rewritten and narrower, or it may fade into the footnotes of an extraordinary presidency. In either case, the ruling of May 28, 2025, will stand as a marker the day the judiciary reminded the executive that even in emergency, the old parchment still draws red lines. Until the next chapter, the world's cargo waits at the water's edge, containers stacked like questions, answers delayed by the tide. You've been watching Nexus Feed Breaking? For more analysis into global news, please subscribe to the channel. Hit the like button so it can be recommended to other viewers, and share the video. Let us know what you think in the comments section too. And until our next one, keep questioning, keep exploring, and stay informed.